Okay, welcome back to the deep dive. Today, we're taking a really close look at a stack of sources, all focusing on what many call the absolute cornerstone of the Indian Constitution. That's Article 19.
That's right. Yeah, if you think about fundamental freedoms in India, Article 19 is really, well, it's right at the heart of it all. Our sources today, we've got legal articles, some analyses, even recent news bits. They really showed just how broad this one article is.
It seems to cover so much ground.
It really does. Everything from, speaking your mind freely, gathering with others peacefully, forming groups or unions, even moving around the country, living wherever you choose within India and picking your job or running a business. It's huge.
And what these sources do so well, I think, is they kind of peel back the layers on these rights. Where did they come from? How have the courts interpreted them? How have they evolved? What do they actually mean in practice day to day? And maybe most importantly, these reasonable restrictions that come along with them.
Exactly, because that's crucial. These rights, they aren't absolute. There are limits.
Right.
So our mission today really is to explore these sources. We want to understand the true scope of these freedoms, get a grip on their limitations, see how the courts have shaped them over time through some really key landmark cases, and ultimately just grasp why they are so vital. Vital for India's democracy and vital for you as a citizen.
Okay, sounds like a plan. Let's unpack this.
All right. So first off, where does Article 19 actually sit in the Constitution?
Well, it's right there in Part 3. That whole section is dedicated to fundamental rights, running from Article 12 right through to 35.
And it's described as a kind of shield.
Yeah, that's a good way to put it. It's basically designed to protect citizens, protect them from potential overreach or undue interference by the state.
So the original idea was really about safeguarding those core personal rights. Speech, assembly, forming groups.
Precisely. Things that are just absolutely essential if you want a society that's vibrant, participatory, and, well, truly democratic.
It lets you actually engage in the process. Exactly. These rights aren't just nice ideas on paper, they're fundamental to actually running a democratic society. They encourage everyone to take part. And one really key detail our sources highlight. The rights under Article 19, they specifically apply to citizens of India.
Ah, okay. So not for non-citizens. That's an important distinction.
It is. It's specifically about the rights granted to Indian citizens by the Constitution.
Got it. So the main grant of these freedoms is in Article 19, Clause 1, right? Which lists 6 freedoms.
Yes, that's the core list. Article 19.1 lays out 6 fundamental freedoms, although, as we keep saying, they're all subject to those reasonable restrictions.
Let's quickly run through them.
Okay. First, there's the freedom of speech and expression. That's Article 19.1a, very well known. Second, freedom to assemble peacefully and without arms. That's 19.1b. Third, freedom to form associations, unions, or even cooperative societies. That's 19.1. Fourth, freedom to move freely throughout the territory of India. 19.1d. Fifth, freedom to reside and settle in any part of the territory of India. And sixth, the freedom to practice any profession or to carry on any occupation, trade, or business. That's 19.1g.
Okay, that's 6. But hang on, I thought the outline mentioned something about Article 19.1 being removed. The right to property.
Good catch. Yes, originally there were 7 freedoms listed there. The right to hold, acquire, or dispose of property was under Article 19.1, but it got taken out of the list of fundamental freedoms by the 44th Amendment back in 1978.
So it's gone completely.
Not completely gone from the Constitution. It was moved. It now exists as Article 300A. So it's still a constitutional right, a legal right, just not a fundamental right under Part 3 anymore.
Okay. Interesting distinction. So for our focus today under Article 19, it's these 6 core freedoms. Let's dive into the first one, 19.1, freedom of speech and expression. This one seems to generate a lot of heat, a lot of discussion.
It absolutely does. It's often called the bedrock of democracy, isn't it? It's fundamentally about allowing you as an individual to speak, to express your thoughts, your views, share information, all without fear of the government censoring you or punishing you for it.
And it's not just talking, right? The sources say it's broader.
Much broader. It covers expressing yourself through any medium, writing, art, online, whatever, holding opinions. And crucially, it also includes the right to receive information and to impart it. So it covers propagation, publication, circulation of ideas, the whole chain.
So it protects my right to hear what others are saying too.
Exactly. That receiving part is just as important. The core idea is protection from unnecessary government clamps on expression. But, and we'll keep coming back to this, Article 19.2 makes it very clear. This right is not absolute. There are limits.
Yeah, we'll get to those limits. But what's fascinating from the sources is how the courts have kind of stretched the definition of this right over the years. They've included things not explicitly spelled out in 1901.
That's where it gets really interesting, legally speaking. Take freedom of the press, for instance. It's not literally written freedom of the press in Article 19.1, but the courts, right from the early days, cases like Romesh Thapar v. State of Madras, they definitively said, yes, freedom of the press is an essential, implied part of the freedom of speech and expression.
Often called the fourth pillar of democracy.
Exactly, seen as indispensable, and the sources break down what that means practically. Things like, generally, no pre-censorship before publication, freedom to publish, and freedom to circulate what's published.
That Romesh Thapar case was key on circulation, wasn't it? Saying it's just as vital as the act of publishing itself.
Precisely. I mean, what good is publishing something if you can't get it out there for people to read or see? Another huge one derived from this is the right to know and obtain information.
Where did that come from?
Well, the Supreme Court, especially in a case called State of UPV Raj Narain, essentially said that freedom of speech implies a right to know. The logic is, for a democracy to work, for government to be accountable, citizens need information. You need transparency.
And that led directly to the RTI Act.
It paved the way, absolutely. That judicial interpretation was a massive step towards the Right to Information Act of 2005, a huge tool for citizens.
Wow. Okay, so that right we use today has roots right back in Article 19.1.
It does, and it extends even into elections. The sources point out that voters have a fundamental right to know the antecedents of candidates.
Meaning their background, criminal records.
Exactly. Cases like Union of India v. Association for Democratic Reforms established this. The idea is you need this information to make an informed choice. And recent rulings mentioned in the sources have even tightened requirements on how quickly candidates have to publish this kind of information.
So my right to speak includes my right to get information about who I might vote for. That makes sense. What about a right to reply?
Yes, that's also seen as part of 19. If something is published about you, you generally have a right to get your response published in the same place. The LIC v. Prefemify Shah case is often cited here.
Okay, and this one always gets people talking. The right to silence. How is staying silent part of freedom of speech?
Well, it's sort of the flip side of the coin, isn't it? Expression includes the freedom not to express or not to be compelled to speak. The famous case, Bijo Emmanuel v. State of Kerala, is the classic example.
National anthem case.
That's the one. The court upheld the right of children from the Jehovah's Witness faith not to sing the national anthem in school based on their religious beliefs. They linked it back to freedom of expression, which includes the right not to speak or the right to remain silent.
That really shows how far the interpretation goes.
Yeah.
What about flying the national flag?
Also covered, flying the flag respectfully, as the court held in Union of India v. Naveen Jindal, is considered an expression of your allegiance, your pride. So it's a fundamental right under 19.1a.
But not for commercial gain, right?
Right. You can't just slap it on any product for advertising. It has to be done with respect.
Okay, so that's a surprisingly wide range of things covered under just speech and expression. But now, let's pivot to those crucial, reasonable restrictions. Because as you said, the right isn't unlimited. Article 19.2 lists the specific reasons the state can limit free speech.
Exactly. The state can impose restrictions, but only, and this is key, only in the interests of certain specific things. Let's list them. Sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, or, finally, incitement to an offense.
That's the full list.
That's the exhaustive list under 19.2 for restricting speech and expression. The restriction has to fit into one of those boxes.
And the sources really dig into how this plays out in some tricky, often controversial areas, like sedition laws.
Right. Sedition, Section 124A of the Indian Penal Code. It punishes speech that tries to incite hatred, contempt, or disaffection towards the government. Historically, the courts, in cases like Kedar Nath Singh, upheld this law. They looked at whether the speech had a calculated tendency to disturb public order.
So it's a classic clash, security versus criticism.
It absolutely is, a real tension point. But the sources also flag significant recent concerns. People are questioning its constitutional validity today, its scope, whether it's being used sometimes to shut down legitimate criticism, not just incitement to violence.
That S.G. Vambatkar petition by journalists is mentioned.
Yes, that's highlighted as a recent example, pushing for a re-examination of the law, asking if it aligns with today's constitutional promises of free expression. It's a very live debate, showing that tension is still very much there.
Okay. What about hate speech? How do the restrictions apply there?
Hate speech is usually tackled using restrictions related to public order, decency, and morality. There are various laws, sections in the IPC like 153A, 295A, and also in the Representation of Peoples Act, that punish speech aimed at promoting enmity between different groups or outraging religious feelings, especially relevant around election time.
And the Supreme Court is concerned about this.
Yes, the sources mention the court expressing concern over rising incidents, even directing authorities to take action on their own initiative, suo motu, in the Shaheen Abdullah case. But interestingly, the court hasn't formally defined hate speech as a distinct legal category itself. They've asked the Law Commission to look into it, as noted in the Pravasi Balai Sangathan case.
And that report about lawmakers facing hate speech cases themselves? That's concerning.
It certainly raises questions about standards and accountability, as the ADR new report highlights.
Okay, then there's defamation as a restriction. How does that balance out?
Defamation law essentially tries to balance your right to speak freely under 19.1 against another person's right to reputation, which the courts often link to the right to life under Article 21.
Reputation is part of the right to life.
That's how the courts have often viewed it. And in India, unlike some places, both written defamation, libel, and spoken defamation, slander, can be criminal offenses, not just civil wrongs. The aim is harmony. Your free speech doesn't give you a license to unjustly destroy someone's reputation. But, the sources also caution, criminal defamation shouldn't become a weapon to silence critics. Complaints need real evidence.
Right. What about censorship, particularly for things like films?
Film censorship has been upheld by the courts as constitutionally valid under the 19.2 restrictions, citing cases like K. Abbas v. UOI. The reasoning often given is that films can have a more immediate, powerful emotional impact compared to, say, print media.
But there's pushback there, too.
Always. There's a constant tension. The sources mentioned the Rangarajan case, where a film ban was overturned because it was seen as stifling legitimate criticism of government policy. And you see it playing out even now with debates around films like Lipstick Under My Burqa, Indu Sarkar, or documentaries facing hurdles. It's an ongoing struggle.
It sounds like the courts are constantly performing this balancing act. And speaking of balance, there were some recent strong comments from the Supreme Court mentioned.
Yes, that was quite notable. A ruling where they canceled a police case, an FIR, over a poem. The court really emphasized that freedom of expression is integral to a healthy society, and they specifically warned against judging restrictions based on the reactions of insecure people who see threats everywhere.
They said restrictions must be reasonable and not fanciful.
Exactly. Reasonable and not fanciful and obstructive. A clear signal that courts and police need to ensure restrictions are genuinely justified and proportionate, not just knee-jerk reactions.
That feels like the judiciary pushing back against overly broad interpretations of those restriction grounds.
It does highlight their role as the ultimate arbiter, constantly checking if restrictions are truly necessary. And this applies online, too. Remember the Anuradha Basin case regarding the internet shutdown in Jammu and Kashmir?
Yes.
The court explicitly recognized the internet as a vital tool for exercising rights, like speech and profession. They said any restrictions on internet access must meet strict tests of necessity and proportionality. You can't just shut it down lightly.
Okay. That covers a lot on speech.
Yeah.
Let's move to the next one. Article 19(1)(b), the freedom to assemble.
Right. This is your right to gather together with others, peacefully, and without weapons. Think public meetings, demonstrations, processions, marches.
It seems like a natural follow-on from free speech, doesn't it?
Yeah.
You talk, then you gather to amplify the message.
It's often seen exactly like that, a necessary corollary. You express views, then you come together collectively.
But there are limits on where you can assemble.
Oh, definitely. The sources are clear. This isn't a right to assemble just any way you fancy, not on government property without permission, and certainly not on someone else's private land.
And like speech, it has restrictions under Article 19(3).
Yes. Restrictions on notably are allowed, but again, only for specific reasons.
Which are?
Only two grounds here. In the interests of the sovereignty and integrity of India, or in the interests of public order.
Public order seems like the main one in practice for protests and meetings.
It often is, but the courts have put limits on how that's applied. For instance, in Himat Lal v. Police Commissioner, Bombay, the court said the police couldn't just impose a blanket ban on all public meetings. Regulation is okay, total prohibition isn't.
So the state can manage time, place, manner, but not just forbid assembly altogether.
That's the gist. And the Ramlila Maidan incident case was important too. The Supreme Court condemned the forceful police action against sleeping protesters as a violation of their right to peaceful assembly. It underscored the importance of the right.
And I guess that internet shutdown case, Anuradha Bhasin, is relevant here too, since organizing assemblies often relies on communication.
Absolutely. In today's world, assembly often depends on digital communication tools, so restricting the internet directly impacts the ability to assemble, making that necessity and proportionality test vital for internet curbs as well.
Okay, moving on to Article 19(1). Freedom to form associations, unions, and cooperative societies.
Right. This is about joining together more formally, setting up organizations, companies, societies, political parties, trade unions, social clubs, cooperatives, achieving common goals together.
Does this also mean you have a right not to join?
Yes, interestingly, it does. The sources point to the Excelware case, confirming that the freedom to form an association includes the inherent right not to be forced into one. It also protects the right of existing members to keep their association going with its voluntary membership, as seen in the Damayanti case.
Can the government put people into associations like nominating members to a co-op?
The sources indicate that the state can nominate members from weaker sections into cooperative societies, and that's generally seen as okay, not a violation. However, the state can't stop you from forming an association in the first place. No prior restraint on formation itself.
But forming an association doesn't mean the government has to recognize it.
Correct. There's no fundamental right to government recognition. And another crucial point. The right is to form the association. It doesn't automatically guarantee the right to achieve whatever the association wants to do.
So the association's objectives still have to be lawful.
Exactly. And those objectives themselves might be subject to other laws and reasonable restrictions.
And the restrictions specifically on forming associations are under Article 19(4).
That's right. Restrictions here can be imposed in the interests of the sovereignty and integrity of India, or public order, or morality.
Any key case illustrating this?
The Bangalore Medical Trust case is mentioned. It involved balancing the state's duties, like planning urban development, against the rights of individuals, like doctors forming a cooperative for medical facilities. It highlights that balancing act again.
Okay. Now, Article 19(1), D and E, freedom of movement and freedom of residence. They seem very closely linked.
They really are. They're seen as complementary rights for citizens. 19(1)D gives you the freedom to move freely anywhere within India's borders, and 19(1) gives you the freedom to live and settle down in any part of India.
So as a citizen, I can basically travel anywhere and live anywhere I choose within the country.
That's the core principle, yes. The right to move freely, the Karak Singh case confirmed this, includes the basic right to locomotion using roads and highways, and the right to reside isn't just about being allowed to be somewhere. Courts have linked it to the right to shelter, even constructing houses, like in the UP Abbas Evam Vikas Parashad case.
That's quite significant, touching on fundamental things like housing and travel. What are the restrictions here? Under 19(5)?
Yes. Article 19(5) allows restrictions on both movement and residence. The grounds are in the interests of the general public or are for the protection of the interests of any scheduled tribe.
That second one is specific. Why protect scheduled tribe interests?
It recognizes the need to protect the distinct cultures, lands, and ways of life of tribal communities from being overwhelmed by outsiders settling in their areas. It's a protective measure.
Makes sense. Are there cases showing how these restrictions work?
Well, the Dr. N.B. Care case showed the state can restrict movement for security reasons, upholding an externment order under a Safety Act. But the Ibrahim Wazir Mawat case is really important on the limits. It involved a law controlling entry from Pakistan after partition. The court struck down a section that effectively deported citizens who had entered without permits, saying it violated their fundamental right to reside under 19(1), even if the government argued it was in the public interest.
So even public interest couldn't override a citizen's fundamental right to reside in that instance.
Exactly. It showed how strongly Article 19 protects citizen rights against state action, drawing a clear line.
Okay. Finally, let's tackle Article 19, freedom of profession, occupation, trade, or business.
Right. This is your fundamental right as a citizen to engage in economic activity, to choose how you earn your living, whether it's a profession, a job, a trade, or running a business.
What's the scope? Does it mean I can do absolutely anything?
It means you have the freedom to choose and pursue a lawful economic activity. Interestingly, the sources note it also implies the right not to carry on a business, or even the right to close down a business.
The right to close shop.
Yes, the Excelware case again. It struck down a law that said businesses needed prior government permission to close. The court said forcing a business to stay open against its will violated 19(1)(g).
So freedom includes the freedom to stop. What's definitely not included in this right?
Okay, several things. You don't have a fundamental right to be given a particular job, like a specific government position. You certainly don't have a right to carry on activities that are inherently dangerous, criminal, or fundamentally antisocial, like maybe trafficking or illegal gambling.
Makes sense.
Also, importantly, there's no fundamental right to do business with the government. The government can choose who it contracts with, and your right to trade doesn't protect you from fair competition in the marketplace.
Right. No right to a monopoly unless the state creates one.
Precisely. And one more crucial extension the sources highlight: sexual harassment at the workplace. The landmark Vishaka case established that a safe working environment free from sexual harassment is essential for women to exercise their right under 19(1)(g) to practice their profession or carry out their occupation. That case led to the Vishaka guidelines.
That's a really important connection now. The restrictions under Article 19(6),
Right. Like the others, restrictions can be imposed in the interests of the general public. But 19(6) also has two specific additions. First, it explicitly allows the state to create monopolies for itself, either fully or partially, in any trade, business, industry, or service.
so nationalization is permitted.
Yes, your right to trade essentially yields if the state decides to run that particular service or industry itself. Second, 19(6) allows the state to prescribe, by law, the necessary professional or technical qualifications for practicing certain professions or carrying on certain occupations. Think doctors needing medical degrees, lawyers needing law degrees, etc.
Okay. That phrase, in the interest of the general public, still sounds very broad, though.
Yeah.
How have the courts interpreted that for restricting business or professions?
You're right, it is broad. The Supreme Court, in the state of Gujarat v. Mirzapur Moti Qureshi Kasab Jamat case, often called the cow slaughter case, said this phrase has a very wide meaning. It includes things like public order, health, security, morals, the overall economic welfare of the community. It can even be linked to achieving the directive principles of state policy found in Part 4 of the Constitution.
So the state does have quite a bit of leeway there. But restrictions still can't be arbitrary, can they? They need justification.
Absolutely. That's always the check. They must be justified and not arbitrary. The Sagir Ahmad case, involving restrictions on private bus operators, is an example where restrictions were struck down because they were seen as an unjustified deprivation of the right to carry on business. It always comes back to that need for a rational connection, a reasonable basis for the restriction.
Which brings us perfectly to this core concept that runs through everything we've discussed: reasonable restrictions. How do the courts actually decide if a restriction is reasonable? It sounds subjective.
It's definitely the heart of the judicial review process for Article 19. There are a few key elements. First, any restriction must be imposed by authority of law. It has to be based on a valid law passed by the legislature, not just an arbitrary executive decision. Second, the restriction itself must be reasonable. And the courts, especially after the landmark Maneka Gandhi case, have said reasonableness includes principles like proportionality, fairness, and adhering to natural justice. It can't be excessive.
Is there a kind of checklist or test the courts apply?
Yes, the sources outline a sort of three-part test of restrictions, drawing from Article 19(2) through 6. 1, is the restriction imposed by or under the authority of a duly enacted law? Romesh Thapar established this early on. 2, is the restriction imposed for achieving one of the specific purposes or objects listed in the relevant clause of Article 19? Sovereignty, public order, morality, general public interest, etc., depending on the freedom.
And there has to be a link.
Yes, that's part 3. There must be a reasonable nexus or rational connection between the restriction imposed and the objective it's supposed to achieve. Bangalore Medical Trust is a good example here. And the restriction itself must be reasonable in substance. Maneka Gandhi emphasized this.
That principle of rational nexus seems really important. It stops the state just picking a listed ground out of thin air.
Exactly. It prevents arbitrariness. The restriction has to actually logically serve the stated purpose, like security or public health. It can't be disproportionate to that goal. Cases like Amar Ali Sarkar or R.K. Garga have used this principle to strike down restrictions that were found to be discriminatory or lack that rational link.
And that list of grounds in 19.226, like public order, morality, etc., is that list final? Can the state add new reasons to restrict these freedoms?
The sources confirm the Supreme Court has consistently said no. Those grounds listed in clauses 2 to 6 are exhaustive. They are the only permitted justifications for restricting Article 19 rights. The state can't invent new reasons. The V.G. Roe case stressed this for associations, and more recently, the Kaushal-Kishore case made it clear you can't use, say, Article 21 rights like dignity as a basis to restrict Article 19 speech because dignity isn't listed in Article 19.2.
Okay, so the rights aren't absolute, but the state's power to limit them is also very specifically constrained by the Constitution itself.
Precisely. That's the fundamental balance Article 19 tries to achieve.
Right. So let's try and pull this all together. Article 19, it really stands out as this, well, lighthouse of freedoms for citizens in India.
It absolutely does. It empowers individuals, gives them liberty and choice, but it also acts as that crucial check, that barricade, against potential overreach by the state.
And it's fundamental for democracy, right?
Right.
People need to be able to speak, gather, make choices about their lives, their work.
Without unnecessary barriers, yes. That's how you get meaningful participation, how you keep the government accountable. A vibrant democracy needs these voices to be heard.
So Article 19 is really India's constitutional commitment to democracy and individual freedom embodied for its citizens.
You could definitely say that. It's tangible.
And if someone feels these rights have been violated, what can they actually do? What's the remedy?
There are powerful remedies. You, as a citizen, can go directly to the High Court under Article 226, or even directly to the Supreme Court under Article 32 by filing a writ petition. These courts are considered the guardians of the Constitution and fundamental rights. They can issue various kinds of writs.
Like habeas corpus? Gangs.
Exactly. Habeas corpus if you think someone's unlawfully detained. Mandamus to order a public authority to do its duty, certiorari to quash an unlawful order. There were several types. And public interest litigation, PIL, is another important avenue, especially if the violation affects a larger group or the public.
So the judiciary plays a critical role in actually enforcing these rights.
Absolutely essential. Without the court stepping in, these rights could just remain on paper. And it's worth remembering, generally, these Article 19 rights are protections against the state government bodies, legislature, etc. Private individuals or non-governmental bodies typically can't violate your Article 19 rights directly, though their actions might lead to state intervention or other legal issues.
Okay. And one last point. Fundamental rights can be amended. We saw that with the property right.
Yes. 1911 was removed by amendment.
But there's a limit to amendments, too. The basic structure doctrine.
Exactly. While amendments are possible, the Supreme Court has held that Parliament cannot pass amendments that destroy or damage the basic structure or core features of the Constitution. So, any amendment drastically altering the essence of Article 19 freedoms would likely be challenged and subject to judicial review on those grounds. It's a kind of ultimate safety net.
Okay. So we've covered a huge amount of ground today. We've journeyed through this whole landscape of Article 19, from the really broad strokes of free speech, press freedom, right to know, even the right to silence, to the rights to assemble, form associations, move around, live somewhere, choose your work.
And we've consistently seen this balancing act, haven't we? The courts grappling with how to weigh these incredibly important freedoms against the restrictions the state argues are necessary for society to function. Using those tests, reasonableness, rational nexus.
Yeah, and those ongoing debates we touched on, sedition, hate speech, censorship, they really show this isn't settled law. It's a dynamic process, constantly being tested and refined.
That recent Supreme Court comment about restrictions needing to be truly reasonable, not just reactions from insecure people, feels like a very current marker in that ongoing refinement.
What really stands out, I think, is that while these rights are fundamental, what they mean in the real world isn't fixed. It really depends on court interpretation and the specific facts when a restriction is challenged.
Absolutely. It demands constant vigilance, both from citizens and the judiciary.
And for you, listening to this, understanding Article 19 really gives you a powerful lens, doesn't it? It helps you understand government actions, your own rights, your place in the whole democratic setup. These aren't just abstract legal ideas. They affect your life every day, what you can post online, where you protest, where you choose to live, the job you do.
And that brings us to something really interesting to think about. Considering this constant tension, this push and pull we've discussed between your fundamental freedoms and the state's power to limit them for reasons like public order or the general public interest, it raises a question for you to ponder. How do you personally see that line? Where do you draw the line between exercising your own fundamental rights and respecting the limits that might be needed for societal harmony and order, maybe in your own life or in your community?